The second document talks about a power of attorney. So while the will comes into play after you pass away, the next three documents are more about what happens when you're alive, right? So while you're alive, you have this document called a power of attorney. A power of attorney is a document that can be either effective right away, which is durable, or it can be springing, which, as the name suggests, springs into effect at a future point in time, which is your incapacity, right? So that's usually done by a doctor in writing, or maybe two doctors in writing. Generally speaking, when you have a couple with a long-term marriage, it'll be a durable power of attorney. But there are certain circumstances when a springing might be relevant and more, important to do. But I would say, for the most part, we use durable. Okay. All right. Now, the next slide talks about what agents you can have, right? So when you have an agent in your documents, you want to talk about, well, what happens? Do they act together? Or do I have more, if I have more than one, or can they act separately? So the default under the law is that they must act together. However, there is a space on the document where you can initial and indicate that, yes, they can act separately. Now, there are differing opinions on, there's lots of reasons why you'd want them to act together. So you have checks and balances, or that, acting separately, you trust them, and maybe one lives in California and one lives in New York, and it's more convenient to have them to act separately. Practically speaking, just be aware that if you do name more than one, some financial institutions, two come to mind immediately that I've worked with, will require both of them, even if you initial separately. So there are some weaknesses. The power of attorney's been modified several times over the last 15 years, and there's more teeth in the statute now to enforce these with financial institutions, but just practically to be aware that that could happen. You can describe specifically, there's lots of space for you to make modifications in your power of attorney. So you can say, if A is not available, then B, if B is not available, then C, so that they can act in succession, so you can be very specific.